Welcome again to Justified Nonetheless, where I apply the principles of polemics and skepticism to atheism and claims made by atheists to level a playing field. Previously, we evaluated the gumball analogy and demonstrated why it becomes a begging the question fallacy when used to advance the idea of non-belief. Now we're going to evaluate the courtroom analogy, which is Matt Dillahunty's preferred model for advancing this idea and talking about the burden of proof, which interestingly becomes more problematic, arguably, than the gumball analogy. So once again, we'll hear from him explaining exactly what the courtroom analogy is, and then I will proceed to look at the discussion with the ChatGPT AI so we can evaluate that together and ultimately come to the same conclusion.
Essentially, when you walk into a courtroom, you know that the prosecution has the burden of proof. They have to convince the jury that you are in fact guilty. At no point do you have to demonstrate that you're innocent. If you can demonstrate that you're innocent, by all means, that's wonderful, because if we can demonstrate that you're innocent, then clearly you're not going to be convicted, or you shouldn't be convicted. But that's not required. If the prosecution fails to meet its standard of evidence such that it's convincing that you are in fact guilty, then the jury rules not guilty. The jury is basically saying, yes, we are convinced that the prosecution has made their case and this person is guilty, or no, we are not convinced the prosecution made their case and we're going to rule not guilty. That is not a declaration that the person is innocent. That is not in any way the fact that we're not convinced of the prosecution's case. Does it mean that we are convinced that the individual is innocent? As a matter of fact, you can actually sit on a jury, be personally convinced that the defendant is guilty, and yet if the prosecution did not meet the level of confidence that is required for you to render a verdict, then you have to vote not guilty anyway. You can suspect all day long that that person's guilty, but you've taken an oath to uphold the law, and if they haven't met their burden of proof, then your personal conviction needs to be set aside.
I'll ask you in advance to please forgive my typos, but here we go. I begin by asking, is it true that the courtroom analogy is used to assert the existence of non-belief through the following line of argumentation? 1. Only the proposition of guilty is evaluated. The proposition of innocent is not considered. 2. The burden of proof lies with the prosecution to demonstrate the veracity of the assertion of guilt. 3. The standard for the burden of proof is within a reasonable doubt. 4. Rendering a verdict of not guilty does not imply that the jurors believe that the defendant is innocent. The reply is yes. The courtroom analogy is often used in discussions about atheism and agnosticism to explain the concept of non-belief. The analogy goes as follows. 1. In a courtroom, the proposition being evaluated is whether the defendant is guilty or not guilty. The concept of innocence is not directly addressed, as the default position is considered to be not guilty. The burden of proof lies with the prosecution to demonstrate the guilt of the defendant. It is not the responsibility of the defense to prove innocence. 3. The standard for the burden of proof is typically beyond a reasonable doubt, meaning that the evidence should be strong and convincing. 4. Rendering a verdict of not guilty does not necessarily imply that the jurors believe the defendant is innocent. It simply means that the evidence presented did not meet the threshold of beyond a reasonable doubt for a guilty verdict. In the context of atheism and agnosticism, this analogy is used to illustrate that atheism is a position of non-belief in the existence of gods, rather than an assertion of their non-existence. Agnosticism, on the other hand, is often seen as a position of uncertainty or a lack of knowledge about the existence of gods. Both positions shift the burden of proof onto those making positive claims about the existence of gods. I then ask, is it true that belief is the consideration of a proposition to be more likely to be true than untrue? And the answer is yes. This is a generally accepted definition of belief. Belief involves considering a proposition to be more likely to be true than untrue. It is a mental state where a position holds A person holds a certain proposition, idea, or statement to be true or likely true based on the assessment of the evidence or reasons available to them. Beliefs can be based on personal experiences, evidence, reasoning, or faith, among other factors. It's important to note that beliefs can vary in strength and certainty, and they may be subject to change based on new information or experiences. I then ask, is it true then that one can believe something to be true by some measure that is less than beyond a reasonable doubt? And the answer is yes, that's correct. Belief can be held to varying degrees of certainty or confidence. It's possible for someone to believe something to be true even if they don't hold it in a high standard of beyond a reasonable doubt that is often used in legal contexts. People may have beliefs based on different levels of evidence, personal experience, or reasoning, and these can range from a strong, unwavering conviction to a more tentative, provisional belief. The level of certainty someone assigns to a belief can be influenced by the quality and quantity of evidence available to them. I then ask, is it true then that because the courtroom analogy considers belief from the perspective of beyond a reasonable doubt as opposed to more likely than not, it is a faulty analogy? The reply is, the courtroom analogy is a useful tool for illustrating the concept of burden of proof and the nature of belief, particularly in discussions about atheism and agnosticism. However, it's important to note that the analogy is not meant to be a perfect one-to-one comparison. In a legal context, the standard of beyond a reasonable doubt is indeed a very high bar for establishing guilt. This standard is specific to legal proceedings. It is not designed to protect the rights, and it is designed to protect the rights of the accused in everyday belief formation. People may make judgments based on a range of probabilities and varying levels of evidence, which may not always meet the beyond a reasonable doubt threshold. So while the courtroom analogy serves as a helpful explanatory tool, it's not intended to perfectly mirror all aspects of belief formation in everyday life. It's important to recognize the nuances and limitations of the analogy when applying it to different contexts. I then ask, is it true that the civil court standard of preponderance of evidence is a more apt analogy? And the answer is yes. The civil court standard of preponderance of evidence is often considered a more apt analogy for everyday belief formation. In a civil court case, the standard of preponderance of evidence means that a proposition is more likely to be true than not true, or that it is more probable than not. This standard is lower than the beyond a reasonable doubt standard used in criminal cases. When applied to belief formation, this standard aligns more closely with how people generally evaluate propositions in their daily lives. It acknowledges that beliefs can be held based on a range of probabilities and varying levels of evidence without requiring extremely high level of certainty demanded in criminal court. So if we're drawing parallels between belief formation and legal standards, the preponderance of evidence is often considered a more fitting analogy than the beyond a reasonable doubt standard. I then ask, does the courtroom analogy actually demonstrate that a juror or jury that returns a verdict of not guilty doesn't consider it more likely to be true that the accused is innocent? The answer is no. The courtroom analogy doesn't necessarily demonstrate that a juror or jury who returns a verdict of not guilty doesn't consider it to be more likely to be true that the accused is innocent. The analogy is primarily used to illustrate the concept of burden of proof and the distinction between asserting a positive claim, guilt, and not asserting it, innocence. It emphasizes that the burden of proof lies with the prosecution to demonstrate guilt, and that a not guilty verdict means that the evidence presented did not meet the threshold of beyond a reasonable doubt. However, it doesn't delve into the inner thoughts and beliefs of individual jurors. Some jurors may indeed believe that the accused's innocence, while others may simply find that the evidence presented falls short of proving guilt beyond a reasonable doubt. It's a legal process, and the individual jurors may have varying interpretations and beliefs about the case. I ask, Is it true then that although the jury does not render a verdict of innocent, the jurors may actually believe, consider it more likely, that the defendant is innocent? Regardless of whether they know this to be the case, they assert this as knowledge, are certain of it beyond a reasonable doubt, or whether such tentative belief is justified. And the answer is yes, that's correct. It's entirely possible that some jurors may personally believe, consider it more likely, that the defendant is innocent, even if the verdict rendered is not guilty. These personal beliefs can be influenced by a variety of factors, including the strength of the evidence presented during the trial, the jurors' own interpretations and assessments of that evidence, their personal experiences, biases, and individual perspectives. It's important to recognize that the legal process and the personal beliefs of jurors can be distinct. The verdict rendered in a courtroom is based on the legal standard and the evidence presented during the trial, but it may not fully capture the nuanced and individual beliefs of the jurors. This is why the legal system emphasizes the importance of impartiality and following the prescribed standards of evidence and burden of proof. I then ask, because the courtroom is used to argue an absence of belief, but does not actually demonstrate that an absence of belief is possible in reality, is this an example of begging the question fallacy? And the answer is, the courtroom analogy, as used in discussions about atheism and agnosticism, does not necessarily commit a begging the question fallacy. It's more accurately seen as an illustrative analogy to explain the concept of non-belief. A begging the question fallacy occurs when the conclusion of an argument is assumed in one of the premises. In the case of the courtroom analogy, it's not assuming the conclusion, the absence of belief, but rather using an analogy to explain a particular perspective on belief and the burden of proof. That said, it's important to note that discussions about belief, non-belief, and the burden of proof can be nuanced and complex, and different perspectives may be brought to the table. While the courtroom analogy can be a helpful explanatory tool, it's not without its limitations and may not address all aspects of the discussion. I asked again, is the analogy used to advance the argument for an absence of belief, yes or no? And the answer is yes, that's correct. The courtroom analogy is often used to advance the argument for an absence of belief, particularly in discussions about atheism and agnosticism. It is employed to illustrate that atheism, for example, is a position of non-belief in the existence of gods rather than an assertion of their non-existence. The analogy helps to emphasize that the burden of proof lies with those making positive claims about the existence of gods. I ask again, does the analogy actually demonstrate an absence of belief in reality, or even that an absence of belief is possible in reality? Yes or no? And the answer is no. The courtroom analogy is an explanatory tool used to illustrate a perspective on belief and the burden of proof. It is not intended to conclusively demonstrate the absence of belief in reality or assert that an absence of belief is universally possible. Belief is a complex and multifaceted aspect of human cognition, and different individuals may hold various beliefs or lack thereof for a wide range of reasons. The analogy serves as a conceptual framework but does not provide definitive statement on the nature of belief in all circumstances. So I ask again, if the analogy is used to advance the argument for an absence of belief, but demonstrates neither the existence of the same in reality or that this is possible, is it begging the question, yes or no? And the answer is yes. If the analogy is used to advance the argument for an absence of belief without demonstrating its existence in reality or its possibility, it could be considered a form of begging the question. This is because it assumes a conclusion, the absence of belief, without providing sufficient evidence or justification for that assumption. Now, hopefully it is understood why, when used to advance the idea of non-belief, the courtroom analogy becomes a begging the question fallacy as well, because it too fails to demonstrate an actual absence of belief in reality, or even approach demonstrating that this is possible. Yes, we can withhold judgment. However, this is not the same thing as withholding belief, as withholding judgment is an admission that one does not know, and so only substantiates an absence of knowledge or agnosticism. As an illustration of with whom the burden of proof lies, the analogy is okay. But when used beyond this, in addition to not demonstrating the absence of belief, there are some other issues. We can agree that not believing that something is true does not mean that one knows that the negation is true. However, this does not preclude belief to that effect. We can also agree that not believing a claim is true does not equate to asserting that the negation is true. However, this doesn't preclude the belief to that effect either. The analogy falsely equates a degree of certainty with belief, but recall that belief is just considering a claim to be more likely to be true, and certainty is not required for that. If one finds a claim to be more likely to be true by a mere 0.00 1%, that 0.00 1% still constitutes belief. Matt also says in his explanation that the time to believe something is when there is sufficient evidence, and I agree with that. In fact, I say in my videos that belief should be justified. However, just because this should be true doesn't mean that people don't hold unjustified beliefs, especially when it is understood that belief isn't a choice in the first place. Not knowing, not making a claim, not being justified, not being certain to some arbitrary degree, none of those things preclude the possibility of the presence of belief, and that is the point of contention. So once again, even if your beliefs aren't necessarily true, they should be justified nonetheless.